you become injured, and now you're on disability leave. But your employer has told you, you got to come back to work in a certain time period or else. And understandably, that's got you concerned. It's got you riled up. It's got you scared. You know something? The law is not that black and white. And employers cannot impose a deadline like that on you. And I'm going to explain why. Hi, my name is Shant Kotchounian. I'm the Employment Law Managing Attorney at Michael Burgis and Associates. What I'd like to talk about today is the situations where an employer imposes a time restriction on an employee to return to work. Typically, we'll get calls from clients who let us know that they were fired or they're facing termination because the employer is only giving them 12 weeks of leave. And how that comes to be is typically through the Family Medical Leave Act or the California Family Rights Act. You might have heard that as the FMLA or the CFRA. It does provide 12 weeks of unpaid job-protected leave. What some employers seem to think is that that means it's a maximum of 12 weeks. And guess what? They're wrong. What the law requires is what we call an interactive process. What does that mean? Communication, dialogue, a discussion between you and your boss, between you and your employer to figure out, can there be any solution to the extra time that you might need off work? Maybe all you need is a week. Maybe all you need is a month. Maybe a few months, or maybe longer. There's no hard and fast rule. The employer needs to have that discussion with you to figure out a solution. I can only imagine how it feels to sit there and think that your health is on a timer. And that's not how it should be. I encourage you, if there's any situation that you're dealing with that's similar to this, give us a call. We are here to help you. We'll talk through it and try to steer you in the right direction. Thank you very much.